Greetings, everyone, and a happy new year. I'm attorney mediator Chris Capocha back with you for a new season of the Conflict Counselor podcast. My resolution for this new year is to fulfill our motto, and that is one less dispute in your life. In the Conflict Counselor, I share practical tips on how to avoid everyday disputes and navigate conflict in personal and business relationships based on my experience mediating hundreds of cases. At the 47th District Court in Michigan and in courts throughout the country, residential landlord-tenant cases crowd the dockets. No surprise, really, when you consider that 1 in 3 American households are in landlord-tenant relationships. In this episode of The Conflict Counselor, we'll discuss how landlords and property managers can avoid common disputes with their tenants concerning these issues: the security deposit, rent and utility charges, repairs, environmental hazards, and disturbances. Let's get right to it. First, as to the security deposit, by law it must be refunded to the tenant in a timely manner after lease termination with a written accounting of any charges against it. Now, this is perhaps the number one subject of dispute between landlords and tenants. Landlords should strictly observe the time requirements for security deposit refund and notice of charges. Failure to do so could result in rather stiff financial penalties under local law. Also, the charges should be clearly identified in writing. Now, if the tenant timely objects to the charges, say for unpaid rent, utilities, property damage, or whatever, the landlord must negotiate a settlement with the tenant or file a claim in the district court. Landlords should remember that the security deposit remains the tenant's property until a charge against it has been properly adjudicated. Our next tip for landlords and property managers concerns rent and utility charges, which are often a source of confusion and conflict with tenants. Landlords should explain how these charges are calculated, whether prorated, paid in advance, etc. Many disputes involve the rent due, if any, upon early termination of the tenancy. The lease or other written agreement of the parties should be clear on this matter as well. Rounding out our discussion of tips for landlords are the general requirements of habitability and quiet enjoyment. That is, the premises must be livable and peaceful for the tenant. So, what does this mean? It means, among other things, that repairs must be made in a timely and safe manner. It means that the premises must be free of pests, mold, and other environmental hazards. It means that disturbances by tenant neighbors or the landlord must be alleviated. Indeed, leaky pipes, pesky insects, and noisy neighbors do not make for pleasant living conditions and must be remedied. Probably 95% of the landlord-tenant cases that I mediate every week in court involve the issues and tips we've discussed today. More generally, landlords and property managers can avoid disputes with their tenants by incorporating the following best practices. Use an attorney-drafted lease which addresses the issues covered today. Maintain good communication with tenants, especially when management companies change. Document important communications with tenants in writing and with pictures where appropriate. And perhaps most importantly, treat your tenants as you would want to be treated. It's just smart business, and it's the right thing to do. Thanks again for listening to the Conflict Counselor. We very much appreciate your comments, likes, and follows. Next time, we're going to turn the tables and discuss how tenants can avoid disputes with their landlords. If you are a renter, as many of us are, it's a must listen. See you then.